The opening act is done. We're now going to go to our main performer for today's concert. We're going to Emily Gannon from our Pompano Beach office. You're in for a treat. She really does keep this stuff interesting. The opposite of sounding robotic, Emily Gannon.
Thanks, Jeff. Hi, guys. Emily Gannon from our Pompano Beach office, as he said. Quick, brief overview. Association work is all our firm does. I've been here now 13 and a half years, I believe it is. I'm one of the partners. We have, I think it's like 21 attorneys, 4 different offices, office down in Miami by appointment, Pompano Beach, Palm Beach Gardens, Orlando, Tampa. I joke that, slowly but surely we're taking over Florida. That's the goal, right? But anyway, so let's dive into it. Our biggest thing here is we just like to do this educational, these educational seminars, so you guys can get your credits, obviously, but also so that you're educated and you know what you're doing as board members and as camps. Jeff, did we need to go over anything else?
No, just while you're getting your slides ready, I'm just going to mention that yes, the slides will be available after you fill out the evaluation. The confirmation screen has a link to download them, so you don't have to take crazy notes today if you
Right.
don't want to, because you will get the slides later. And this is being recorded, so you can watch the review on the firm website within a couple of days. And the last few sessions we had the end of July, those will be online later today as well. Emily, back to you.
Great, thanks. All right, here, let me see if I can remember how to share my screen. Always fun to figure that out. Okay. Good, Jeff?
Yeah, I see it.
Okay. So today's class, guys, and again, this is all educational. This is not meant to be legal advice. Just as a reminder, that's your little disclaimer here.
But Emily said this during the class, and this is the way it needs to be.
Exactly. Please don't do that to me.
Don't do that.
So now, and actually funny, because we just had that, my colleague told me they talked to a board member just recently, and she said she took one of our classes, so she knows we already think XYZ. He's like, hold your horses, hold on. But anyway, so today's about guest restrictions, screening, tenants, new owners, all that good stuff. So we're getting into all of those types of topics. I know there's a lot of stuff going on in the world of just, condo, HOA, co-op law in general. Obviously, we teach the board certifications. We also do the legal updates. There was a lot of stuff this year. There's been a lot of stuff in the last couple of years. Milestone, CEUs, all that, interesting new legislation. We're not really getting into any of that stuff today. So that's all good, juicy, fun, interesting stuff too. As Jeff said, those are the longer courses we have, 3 hours, 4 hours. Today is going to feel like probably 5 minutes to me because it's only an hour. So, but this is our only topic. So we're going to talk about restrictions in terms of guests and screening and new owners and that kind of thing, and transfers. That's really our topic for today. So again, if you're going to ask any questions later, let's keep them to just that topic. And that's why we said kind of hold your horses. Let's keep the questions to the end. So let's dive in, because this is a bit of a specific, topic, but again, it's general enough that this is something that probably applies to everybody in every association. All right. So first things first, what are we really talking about when we're talking about screening, restrictions? We're talking about transfers generally. So when a lot has a new owner, or if there's a new tenant that moves in, what about guests? These are all the things you need to look at. The big takeaway here that I'm going to tell you, and you're going to hear me say it probably 1,000 times today, you need to look at your governing documents. Now, go to the next screen here. What can we restrict? Why? Why do I even say governing documents? The hierarchy of your governing documents, and this gets confusing too. We know a lot of owners just sort of, everyone will say, hey, our bylaws say this, or I didn't review our bylaws and I don't know if we can do this. You actually have a number of different governing documents, and that's something to be aware of. Your declaration, if we're talking about a declaration of condominium, then we're in condominium world. If we're talking about an HOA, it's probably your declaration of covenants, restrictions, easements, some variation of that name. But your declaration is your constitution, is what we always call it. That's your number one. That's the top of this pyramid when we're talking about a hierarchy. That should have most of your restrictions. That's probably what we're going to be talking about when we're getting into all the nitty-gritty of what we're talking about today. those things that we're going to get into, those topics, that authority, those restrictions should be in your declaration. You may hear me say deck, it's just shorthand. I don't mean to do that, but declaration. Then we go to your articles of incorporation when we're talking about your hierarchy. Your articles of incorporation, probably not much involved in terms of this analysis, but it is another part of your governing documents you should be aware of. That's what you file with the state. That's how we know that, you're the Greens Association or whatever your name may be. That's how you're filed, and you're an active corporation with the state. Your bylaws, that's the next governing document that in the line there. Your bylaws. So again, when people sort of generally say bylaws, oftentimes they really mean the whole body of the governing documents. But again, I know bylaws sometimes, even though we use it in that way, the bylaws are actually a very specific document. Your bylaws typically sort of have more of your governing language. So how many board members you may have, when your annual meeting is going to be held, what notice requirements you have. That's usually found in your bylaws, your articles maybe, or your bylaws. And then we have your rules and regulations. That's the bottom of the pyramid in terms of the hierarchy. If you have a restriction in your declaration, that would control if there were a conflict between what's in your declaration and what's in your rules. Rules typically are board made. So, and again, this is something where you have to check your documents to make sure, but in most cases, your documents will say the board can adopt rules, maybe about use of the common elements or use of the common areas. The board probably adopts rules in terms of, the hours for the pool, or, things related to the use of the clubhouse. Those are sort of the typical things you think of when you think of board-made rules. But not always. You do want to check your governing documents. Some governing documents do require that members vote on rules as well, or that members have sort of a veto power to rules before rules can be changed. So you do want to see, and you want to look at your governing documents to see what the story is there with any rules. But primarily, and I know I'm sorry if I'm beating a dead horse here, sort of the cheat is dab. A little dab will do ya. Declaration, articles, bylaws, then your rules. If there's, again, any conflict, that's your hierarchy. And like I said, for this topic, when we're talking about guest restrictions and limits on transfers and whether or not the board can even review a sale, review a transfer, typically we're looking at what's in your declaration. So first things first, you want to be familiar with what your governing documents say. That's number one. That's the biggest tip we can take away from today. And you want to know what they say and what authority the board has, and then that way you can act accordingly. So first little note here is the right of approval or the right of first refusal. Which one is in your governing documents? Is there a difference? What do I even mean? What am I talking about here? If your documents say something like the board must approve a proposed lease, something like that, or, the owner must obtain prior approval before leasing and whatever that may be, that would be authority for the board to review leases. Now, if we're talking about a sale or a transfer of a property, this gets a little more complicated. And we won't go back through the whole history, but basically selling property and the right to sell your property and sell land is very important and is, highly valued. People have a problem when you restrict their ability to sell land and sell property. So the way this kind of ended up being somewhat of a compromise here, if the association has the ability to stop a sale, and if the board has the ability to disapprove a transfer and essentially prevent one of its owners from selling their property, they have to have the right of first refusal. And there's a case law behind this, but those two things have to go hand in hand. So to be able to review and disapprove and deny a potential sale or transfer of a property, whether we're talking about a unit or a lot, so again, condos and HOAs, this applies to both of you guys, you have to have the right of first refusal in your governing documents. Now, the right of first refusal, we'll get into in a little bit more detail, but ultimately, that essentially reads as, if the association were to deny this transfer, it then has to provide a substitute purchaser who will follow the same, terms and conditions, who will abide by those same terms and conditions, same price, whatever it is. And they will then they will step in to purchase the property. So ultimately the seller owner does not get damaged in the process. Now, again, there's some technical things to be aware of, and we'll get into that in a minute, but that's the general idea. Screening, background investigation fees, that's important. We get questions all the time. Hey, we have all these applications. Can we charge for them? How much can we charge for them? Can we, it costs our management team or our office staff so much administrative time, so much, effort goes into running these background checks. There's a cost associated with that because we have to use whatever program. And these are good questions. Can you charge for those? And ultimately the answer is going to be, well, do you have the authority to do that in your documents? That's number one. You want to look there. And another thing to be aware of with associations, there's a difference for this topic in terms of if we're talking condo or if we're talking HOAs. In condo world, when we're talking about any background fee, application fee, they call these transfer fees, essentially. The statute actually, and this is only chapter 718, so only condos, the statute actually says you're limited. So you can only charge, and they did raise it in the last, I think, 2 years, so that's nice. It used to be $100. Now it's $150 per applicant. Now keep in mind, when I say per applicant, again, another little technicality here, spouses count as one, and a parent and dependent child count as one. So you can't charge husband and wife each. They count as one application. But that's in 718. That's for condos only, $150. That's what you're stuck with in terms of transfer fees. That's your limit. Now you may tell me, but we use this company that runs background checks and they charge us $150. So we're not getting anything off of it. Or they charge us $200. So why can't we charge the owner $200? Statute says what it says and you're stuck. So ultimately right now it's $150, and that's only again in 718 for condos. The rest of that is ultimately just a cost of doing business. So sorry to be the bearer of bad news there. Now, little difference here, HOA land, so chapter 720, different ballgame altogether. There is no limit. There's nothing restricting you in transfer fees. You can charge that $200 because, we're running a background check that already costs us $150 and we think we have administrative time, or maybe your background check costs $200. Whatever it is, you can charge more is the bottom line. You don't have that same restriction. The statute doesn't address it. Now, another thing to be aware of when we talk about HOAs, many HOAs actually have a capital contribution, some sort of amount that maybe you have to pay when you're initially upon purchasing. Again, that's something that you can do in HOAs. You can have some provision in your deck where it says, new owners upon purchase have to pay maybe 2 months worth of assessments, or maybe there's a flat fee. They have to pay $5,000 to come into our community. And that's money that just goes into the coffers of the association. Again, I think it's something that's a helpful provision to have in your declaration. If you're an HOA, you might want to look into doing that if you're on the board, because ultimately from what we've seen, as long as it's not, a huge capital contribution, it's not going to hurt your sales too much. And it does get some funds coming in and the board has a little bit extra money. So, hey, overall, usually it's a pretty good thing. Consider that if you're doing an amendment, if you're in HOA world. Again, HOAs can do that because the statute doesn't limit transfer fees. Condos, while we think it's been misinterpreted and the division is probably not correct in their interpretation here, they have looked at capital contributions in the world of condos as a violation of that transfer fee limit. So little different. So keep in mind that's something to be aware of. Security deposits, rentals. If you do rent, can we ask the tenant to pay a security deposit? Do we have to have the owner pay a security deposit? How does that work? We're worried that the tenant's going to come in and, they're only here for 6 months. They're going to damage our elevator. They're going to damage the hall when they move in. They may want to, have a party and they damage the clubhouse, whatever else. Bottom line, security deposits, very reasonable request. We see that all the time in rental situations. And That's something too that should be in your governing documents. If you want to be able to request a security deposit for a lease, that should be in your governing documents. Again, these are all things that if you don't already have them, you may want to consider amending and changing your governing documents to reflect these things. Now, what about a move-in, move-out deposit or a down payment requirement? Same thing. You want to have this language in your governing documents. These are not things that traditionally are covered by the statutes. The only thing that's really addressed in the statute is, like I said, that transfer fee issue in 718. But most of the stuff that we're talking about today, when we talk about restrictions and transfers and all of that, most of it is very document specific. So your governing documents are going to control. The statute really doesn't do very much to help you. So ultimately, you can craft your governing documents to suit what you want for your community. So down payments, that's another thing. We do have some associations that require a large down payment in order to approve any sale. Sometimes or certain limit to the financing that's allowed, restrictions like that can be in your declaration. That would be something that ultimately would have to be an amendment if you didn't already have it. Your owners would have to approve it, that kind of thing. Move in, move out deposits, that's a little different. That's something that, arguably you could do by rule. And you could do it where, again, if it's maybe a deposit to use the elevator, to reserve the elevator, as long as that money is ultimately refundable, I think you could do that by a rule as opposed to doing it by amendment. But in general, again, all of these things, when we're talking about charging fees and we're talking about these various restrictions, again, your governing documents are what's going to control here. So sorry again if I sound like I'm beating a dead horse. But that's really important. A lot of people really don't know what's in their governing documents. They just assume, or because we've done things in a certain way for so long, we think we have the authority to do X, Y, Z. Well, make sure that language is actually in your governing documents. All right. And this is now sort of into the meat and potatoes of it all. So what transfers are subject to approval? What are we even really talking about? And we'll give you some examples. We'll talk about this. This is really, again, the crux of our whole discussion here today. You really want to look at your governing documents and make sure the authority that you think you have is the authority that you have as an association, as a board, as a management team. You may come in and be told, oh, everybody, we review everything. Yeah, every sale, everything goes through the management, does an application, the board reviews it. We review everybody. We know everyone who comes in. We know everything about every contract that's been signed, blah, blah, blah. Well, and I've had a client that told me they ran background checks, they required applications, whatever else. And most communities do that. So a lot of people who are purchasing wouldn't think twice about it. Oh, of course I need to fill out an application because, again, very common. But I've also had communities that say they do that. And then we looked at their documents and we said, you actually have no authority to be doing that. You don't have the authority to deny. So why are we running background checks? Why are we looking at applications? If you can't tell somebody no, why do you need to do any of this? There's a difference if you want to just, know who's going to be moving in, you want them to register, you want to get their information, that's one thing. But why are we running background checks on people if we can't deny the application? So you want to make sure you actually know what authority you have, what transfers it applies to. Arm's length sales, that's typically what we're talking about here. That's just your regular sale, regular transfer of a unit, of a lot, whatever it is. Now, as we go down, we get a little more complicated. What about gifts, devises, inheritances? What about if it wasn't quite a sale, but somebody executes a quitclaim deed, and now you have a new owner because they have a quitclaim deed that says, I'm the new owner via a quitclaim deed? What about a life estate deed? What about a remainder man who gets the property because their grandmother passed away and they were named in a life estate? What about putting the property into a trust? What if we put the property into a corporate entity? So it's not a typical sale. Maybe we did it for estate planning purposes and, Mary Smith wants to put it into the Mary Smith Trust. Well, she's still the only interested party. There's no sale here because she's not exchanging any funds. Do we still get to review that transfer? Do we still need Mary Smith to fill out an application? or for the Mary Smith Trust, but we already had Mary Smith fill out the application. Do we still need it? All of these are very important questions. You need to know if your governing documents cover all transfers. And most communities want to be able to review all transfers, I'll be honest. Inheritances, gifts, that's important because a lot of communities, especially we see it in these 55 and over communities, where the property is going to be left to whoever, a child, a grandchild, whatever it is. And if you don't have the ability to then screen that person, you could, you could have a problem, problem grandson moving into the community. You could have somebody who has a terribly long criminal history and you just can't do anything about it because their grandmother left them the property and here we are. Now, all of that could be changed. You could put some provisions in place. Maybe that person could own the property but not live there. Maybe, again, we're looking at, something where it's an inheritance, something like that. You look at it a little differently, but still you could have language in your documents where you do get to review that. And you can say, hey, problem grandson with the, mile-long criminal history, you're okay to own this unit, but you're not moving in here. We don't want you here because you have the criminal history, XYZ. Or, or whatever it may be, or they have no finances, same kind of thing. Some reason where you wouldn't necessarily want that person to be in your community. What if it was an inheritance and you're stuck? We've seen that many times. If you don't have the authority that you think you have, if you don't have the authority to review all transfers, you might have to let, the bum grandson move in. Now, another question is, what about transfers by operation of law? What if, again, it was an inheritance? That's another example. If there's a merger, foreclosure, what about mortgagee exceptions? So a lot of times when you see these foreclosure cases and a lender comes in, lender forecloses, and these are probably going to start ramping up again now, guys, because the way everything's working with the market here in Florida, much more, we're seeing many more cases of these foreclosures. Now, for a long time, foreclosure would happen, lender would foreclose, and there was probably equity, and an investor would buy the property. Great. Now, that raises many questions. Well, wait a minute. We didn't get to review that person. How come, Mr. Jones is now the new owner of Unit 101? We didn't get to screen Mr. Jones. Well, if Mr. Jones bought the property at the lender foreclosure sale, my guess is, and we'd have to look at your governing documents, but most likely, if he purchased it at an auction, at a foreclosure sale, he probably doesn't have to be screened by the association. Most governing documents provide that if the lender forecloses and there is a public auction sale of the property through the foreclosure court, essentially, whoever takes title gets to take title. And they don't go through the same procedure and the application and all of that. You can have that language in your documents. You can require that that person still subsequently be screened. But my guess is your governing documents probably don't already say that. The language that was put in your governing documents originally by your developer, if you think about it, it was there to entice lenders to loan in your community. You wanted owners to be able to get loans. You wanted lenders to be, to have a friendly relationship with your community. So logically, you don't want to put up any hurdles if they had to foreclose. So typically that's the language that's in your governing documents. It will say that if there's a lender foreclosure, and then there's a public auction, whoever purchases at that sale or through that auction does not go through the approval process, does not have to be screened, does not have to pay you the $150 and fill out an application and all of that. And again, you're stuck with them. Now, another sort of step to that, a lot of the governing documents also say, so maybe it wasn't an investor who purchased, maybe the foreclosure sale went through and Bank of America ends up taking title. The next step is, does Bank of America, so if they foreclose and they take title themselves, Bank of America ends up, your unit owner now. If Bank of America now wants to sell it, do you have the ability to review that sale? What if Bank of America wants to lease it? Do they have a special exception? They may, because again, the documents may have been very lender friendly, but you have to look at your governing documents because that's really going to be, again, very document specific. And that could be something you may want to change, you may want to amend down the road. So that's all sort of transfers, leases. Again, quitclaim deeds, is that included when we talk about leases? A lot of old language will just say sales and leases. A sale, again, doesn't necessarily encompass all of these other things we've just been talking about. Leases, that one's pretty easy. Not all, provisions do apply to leases. Sometimes you have the ability to review leases and not sales or not any other transfer. What about if we're just talking about another occupant moving into the unit or moving into the home? Do you guys review them? Do you screen them? How does that work? Are you only looking at, the person who was involved in the initial transfer? What if it's, if we're talking about a 55 and over community, you guys, I know, because of the way the 55 and over laws work, you need to know who your occupants are. You need to know who's in every single home, essentially. You need to make sure somebody's at least 55 years of age or older. So you need to know who the occupants are. Hopefully you're doing surveys every 2 years, and hopefully you're keeping on track of who's in your properties if you're a 55 and over. But ultimately, that's a good question too. What about additional occupants? In that situation where you have, grandma who owns a unit and grandma has a problem grandson and problem grandson moves in, are we allowed to tell grandma we have to screen that person? We have to run their background check. Uh-oh, they have a terrible criminal history. We don't want grandson here. Is that something we can do? Are you doing that? These are all things that would be in your governing documents and you'd need to know. And then again, is there an exception for a family member? Maybe, maybe not. Guests, that's important. What if we get the typical response of, oh, they don't live here. It's just my buddy. He's staying with me for, the summer. Well, do we get to screen that person too? Is he a guest? Is he considered a tenant? What's in your governing documents? What does that mean? Does it make a difference if the owner's in the property or not? Well, he's staying in my house for the summer, but I'm not actually going to be in the house. Does that change the analysis? All of these things are very important considerations. Odds are you may want to know who's in your property. You may, if they're with the owner, maybe you don't care. Maybe you're on a lookout for, Airbnbs. So we want to make sure if they're with the owner, we're okay. If they're not with the owner, we want to treat them as a tenant maybe. But again, that would all be language that would have to be in your governing documents. So like I said, I know I'm going to say it a million times, check your documents. All right.
I think that was number 8.
What?
The 8th time
Oh,
you said, yeah.
Okay.
Not too bad.
So now what? What can we do? What does all of this mean? Choice 1, if we run these background checks, the applications, all that good stuff, you can approve it. Okay. That's the easy one. Gets a little more complicated when we're talking about disapproving potentially. What are we disapproving based on? What's our criteria? What are we looking at? And some are pretty obvious. If you're a, 55 and over community and you have someone who applies, now guys, let me be clear because this confuses everyone. A 55 and over community requires one person to be at least 55 years or age who's a permanent occupant of the unit. Has nothing to do with actually who holds title. It has to do with who's going to be living in the unit or in the home. So this could be a case where you have a couple that's, in their 30s and they're applying to live in your community. And you say, well, we're 55 and over. You guys, wait a minute, you're in your 30s. That doesn't work. You don't fit our criteria. That would make sense. Now, if they were to then tell you, well, we're just buying it in our name, but I'm actually planning on living with, my dad. Here's all of his information. He's 60 years old, then that changes the analysis clearly. But that could be something where if we don't know about dad, if dad was never involved and you just got an application from 2 30-year-olds, it would make sense that you can't approve that because again, right off the bat, they're already in violation of your governing documents. Now, again, that really only works if we're talking about a 55 and over. That's the easiest, most clear example. But also some other things will come up in the application process. You may be a no truck community or a no pet community. And in the application, they've indicated, oh, we actually, both husband and wife drive large trucks, or, oh, we have 4 dogs. Those are all things then you'd have to look into. Well, we're a no pet community. You can't bring them here. We can't approve your application with that already as an outstanding violation. Now, all of this you'd have to get into and we won't go down this road. But obviously, if we're talking about pets, someone may say, Well, they're not pets, they're my emotional support animals, and we can go down that whole road. Again, I don't want to go down that rabbit hole right now, but these are all things you'd want to look at. So on its face, we're looking at what's on your application. Would you already have a violation essentially? That's number one. That's something that, right off the bat, we can look at and we already know. Now, another tip just in general, talk to your management team, make sure your application really fits with the restrictions in your community. Obviously, if you are a no pet building, for example, you might want to ask if someone has a pet. You'd want to know. Then you might want to have another question. What about an assistance animal or emotional support animal, something like that, and give them the chance to indicate there, I don't have a pet, but I do have an assistance animal, so that you're not surprised later on when, Fluffy shows up in the building. And then you can get into that, and we'll talk about that a little bit more in a minute. The big two topics are always criminal history, financial history. That's what we want to really kind of look at. Now, what we're going to tell you too is good cause criteria. Generally, there's probably some authority in your governing documents to look at these things: criminal, financial, all of that. But you really want to have your attorney, our office, whoever it is, put together a more extensive, more detailed list of your good cause criteria. You really want to get into what we're looking at when we're talking about criminal history, what we're looking at when we're talking about financial history, prior bankruptcies, income ratio, all of those things. You can put more information in here and really outline your good cause criteria. And the reason we're doing that is for this last point here, your right of first refusal and the substitute transferee. So this comes into play. Like I said, I talked about it a little bit before. When do we have to exercise the right of first refusal? What does that really mean? Your right of first refusal, if you have that in your documents, and you must if we're talking about disapproving sales, it's going to read, if you deny the sale, the association must provide a substitute transferee, a substitute purchaser. That could be the association, or that could be, someone else that the association knows. It will step in as an investor, whatever it is. But ultimately, you don't have to exercise the right of first refusal as an association. You don't have to provide a substitute buyer as an association if you can disapprove because the application, the person, whatever it is, doesn't qualify under your governing documents. And the only way they're going to not qualify under your governing documents is if we have criteria already in place and you can point to it and say, they don't qualify under our governing documents. Again, the most easy, straightforward example is because we're a 55 and over, and it's two 30-year-olds who told us they're trying to move in. They don't mention anything about a grandpa, an adult, dad, whoever it is. We have an application with two 30-year-olds. That's not going to fly in a 55 and over community. That's, again, just the strict, easiest example to use. But ultimately, that would be something where you could say they do not qualify under the governing documents. Because of that, we're denying the sale. And in that case, you don't have to exercise the right of first refusal. You don't have to give a substitute purchaser. You can just say no. And then the owner has to go find somebody else. So that's really important. That's something to know about. That's where we get this good cause criteria, because you need your governing documents to outline what the criteria is. So you can point to something to say, here's why this application doesn't work. Here's why this purchaser doesn't work, whatever it is. And here's why we don't have to provide a substitute purchaser. We don't have to exercise the right of first refusal. Now, occasionally we've had clients that through the years, there was no real, good reason to disapprove an applicant. They didn't have a criminal history issue. They didn't have a financial history issue. It was just that maybe the application and the sales contract indicated that the unit was going to be sold below market value. And the condo, the HOA, was concerned that they didn't want that to be the last sale in the community. And ultimately, there was no good cause criteria to disapprove. But the association said, we really, really, really want to disapprove because we just don't want this to be the last transfer, on the books. So in that case, we've had condos, we've had HOAs who have exercised the right of first refusal. They have stepped in. The association has said, okay, we'll apply, we'll give you a substitute purchaser. it's the association. The association's going to buy the unit. We're going to step into the shoes of your purchaser. We take the contract. We're going to purchase it, same price. And then ultimately down the road, we're going to turn around and sell it because we think it should be higher. That's really the only time or the most likely time that we see a client actually exercise the right of first refusal, but something you really do need to be aware of. Potential liability, and we touched on some of these things already just in our sort of going through this generally. So you have to be careful about discrimination. That's the big thing when anytime we're talking about applications and reviews and disapprovals and denials and all of that, discrimination is what we need to be aware of. The association does not want to be on the wrong side of a discrimination claim, even if it's completely unintentional, which I would hope it would be. Defending a discrimination claim can be costly, and you're not going to get that money back. But you have to make sure this is why you're applying this criteria across the board. We're not looking at, we're not looking at these categories. We're not looking at race, national origin, familial status, sexual orientation, marital status. And then there are some other categories, and depending on where you are, some of the counties have some additional protected classes. Those aren't the things that we're reviewing when we're reviewing these applications. Again, hopefully, obviously, we're looking at the finances. We're making sure the person can afford to live in our community. We're looking at criminal history because we want to protect our owners, But again, these are things that could all be raised. And in the world of, when we're talking about a 55 and over type situation, familial status is a concern because, again, familial status has to do with pregnancy, children, that kind of thing. And it's sort of a running joke that if you're in a 55 and over, that's the only time you're allowed to discriminate based on familial status, because you're discriminating. You can't allow children there. You're discriminating based on age, essentially. But other than that, if you are a regular community, a regular HOA condo, these are the issues you need to be aware of, and you don't, again, want to run into a discrimination issue. So we want to make sure we're treating everybody the same. We're reviewing applications across the board uniformly and applying our policies, applying our good cause criteria across the board. Disability accommodations and modifications. A person who's disabled is also part of a protected class. So if someone says that they have an emotional support animal, an assistance animal, that's just, again, the easiest example here. You need to make sure you're not just rejecting their application because they indicated they have an animal and we're a no pet building. Well, if it's an assistance animal or an emotional support animal, it's not a pet. That's a key difference here. And again, that would be an accommodation to the pet restriction if this person is disabled. So you would need to do a little more digging, ask them for support for that. You just can't deny it off the bat and say, well, this person has again, indicated they have a dog. Even if it's something like, hey, they have a pit bull and we only allow small animals in our community. Nope. If they're disabled, you may have to allow them. So again, you can't deny the application based on that alone. And if you do, you might be on the wrong side of a discrimination claim. Now, Fair Credit Reporting Act, Florida statutes, you want to look at, in notification requirements, obviously, you want to look at the language in your declaration, make sure you're following that, make sure you're following all the timeframes. If you need to respond within, and it could depend. It could depend on what's in your governing documents, 20 days, 30 days, whatever it is. If you don't respond timely, you may be deemed to have essentially approved the transfer already, so you might be out of luck. The Fair Credit Reporting Act, Florida statutes, you want to look at that because, again, there's some information, there's sensitive information in these background reports that are run. So you need to know what you can disclose, what you can't disclose. Any information you get in the process of doing these applications is not supposed to be open for inspection. So keep that in mind. It goes in your official records, but it's not open for inspection. Make sure you're not divulging, someone's credit score by accident or something. That could open some doors to potential liability there. You may have local ordinances that come into play that also, kind of may dictate your timeframes. Broward and Miami, you have to respond to both an owner and a seller, or the landlord and the renter, and notify both parties within certain timeframes, 15 days, let them know. If something's missing in the application, the ordinance requires that you let them know. These are all potential, spots where the association may get tripped up if they're not doing what they're supposed to be doing. So another hot button issue, guest occupancy. Now I live in South Florida. I know how this works. We hear it all the time. We hear all about Airbnbs. We hear all about people sort of trying to get through the loophole. Oh, I don't have a tenant. It's just my cousin who comes down for the winter. They'll be in my unit. It's not a tenant. No one's paying me rent. I don't have a lease. It's just my cousin. Don't worry about him. It's fine. Well, if you're the board, if you're the association, who's this strange person who just moved into our community? What do you mean we don't get to screen them? It looks like they're a tenant. All important things to consider. Is it a tenant? Maybe not. Can we define in your governing documents that a guest who's in our property for X number of days basically counts as a tenant, regardless of whether or not they're paying rent? We don't care if you have a lease. We don't care if you're paying any money. We just want to be able to know who you are for the security of everybody else. We want to run a background check. We think we should be able to require that you pay an application fee. Do we have any exceptions if we're talking about an immediate family member? Well, all your cousins, that's going to be too far off. But what about your sister, brother, whoever? These are all things you can tailor in your governing documents to require, approval. Non-related guests, do you just want to screen those? Maybe you don't care if, some guests are here, but you do want to, again, over a certain amount of time, or if they're not related, or again, if the owner's in the property too, or if the owner's not in the property. All considerations, all of those terms should be defined in your governing documents. Put that language in there. Talk to your attorney, see what you really want to be able to do here, and make sure that your authority makes sense with what you want. Registration requirements, maybe you don't care about actually having them apply. Maybe you don't want to run a background check, but you just want to know who's there. So you just want a copy of their driver's license or a copy of an ID. So you have some record of it. That's one way to handle it too. What if we have a limit? Okay, we only allow guests to stay for up to 14 days. After 14 days, now they have to be screened. Now we count them as tenants. Or after 30 days, now we count them as tenants. All of these things are important considerations, and your community can essentially set it up however you want. You just have to make sure your governing documents make sense and say what you think they say. All right. Another thing to consider when I'm talking about occupants and occupancy and all of that, again, and when we were talking about discrimination, there's a case where there was a limit in the number of occupants you could have per bedroom. And a lot of communities have that. A lot of governing documents will say you can only have, 2 people per bedroom. And that's how they limit the number of occupants in a unit or in a home. Now, that's not a bad thing. It's just you have to sort of now keep in mind how that could come up. If you have a couple, so maybe, husband, wife, and they're applying to purchase your 1-bedroom unit, but the woman is pregnant. There was a case where an association said, nope, sorry, that's not going to work because we have a limit, 2 people per bedroom. You're already at 2 people. You're pregnant. Can't have a baby here. That's not going to work because that goes above our limit. Well, court said, no, that's not reasonable. That's unfair. Now you're discriminating based on familial status. And it's actually interesting. Broward specifically has an ordinance, and you might want to look at what your local ordinances are in terms of occupancy and that kind of thing. Broward's ordinance is anyone under 10, I believe, counts as half a person for occupancy purposes. So interesting. So those are all things that, again, you could just sort of stumble into a discrimination issue or another problem when you weren't trying to do that, obviously. So practical considerations, this comes into play because, again, you really want to keep an eye on kind of what's going on. If this is something of interest in your community, I assume that's why you're here. That's what you want to know about. We suggest doing surveys. Again, if you're 55 and over, you better be doing them anyway. You should be doing them every 2 years so you know who's in the community. Now, if you have maybe new management, maybe if you're supposed to be looking at leases, maybe you don't track necessarily every single new purchase or every transfer, but maybe you track leases. A lot of HOAs work that way where they don't actually screen new owners, but they screen leases. You want to make sure you're tracking your lease renewals as well. Otherwise, you're going to lose track of all of your leases, and then you're going to have a hard time ever, enforcing your lease approval ability. Track your lease renewals as well. You might have to do a survey to sort of get yourself back on track and see who's in the units, where everybody is, who's there, if they're tenants, if they're owners, et cetera, et cetera. But the lease renewal, we say treat a lease renewal essentially as if it's a new lease. Put that in your governing documents, have it specify, even if the lease is just renewing and we already know this is a good tenant, we want the tenant to stay, we have no problem with the tenant, that's great. But just keep that, have them sort of register again with you. Have them just initiate some sort of approval process. And then as part of that, if you do have problem tenants down the road, then that makes it nice and easy when you say, well, your lease is coming up for renewal, but you guys have been a problem this whole time. We have a record that you threw 5 parties by the pool. You didn't clean up the barbecue. You left trash. You had, cars parked on the grass a bunch of times. We sent you notices. We have record of it. But because you kept doing it, we don't want you here anymore. We're not going to approve the renewal. A lease renewal, excuse me. Lease renewals are important. You want to make sure your governing documents address that as well. And then, like we said, additional occupants, can you screen those additional occupants? Do you want to see what's in your governing documents? Maybe you can adopt some policies to get involved with that. What about the use of your facilities, your common elements, vehicle registration, key fobs, key cards, gate access, your front door procedures? These are all things that you need to keep in mind, and this helps you keep an eye on sort of what's going on. Now, again, for different communities, maybe some of this is not as important, and for certain communities, it might be. We have communities where they're really trying to fight, Airbnb rentals, and they know, because based on where they're located, wherever it is, that the owners sometimes don't listen, and the owners still do Airbnb rentals when they're not supposed to. But they have a security team. They have security guards by the front door. So you're not coming in the building without checking in. And typically when someone shows up with, a rental car and a suitcase, and they say, oh, yeah, I think I'm supposed to be going to unit 502. I don't know. I'm supposed to pick up a key, or I don't know who it is. Well, now we know it's an Airbnb. There are certain ways, just based on having them check in with security, that we can narrow down what those violations are. Then we can go after that owner, let them know we can't be doing that. We've had some in HOAs too, where someone, again, is renting the home on an Airbnb site or similar site, not supposed to be doing that. They pull the whole, I'm not renting my house, it's my, buddy who's just visiting me. Well, that same guy was also delinquent. The association was able to suspend his use rights. They turned off his clicker, his key fob, to come into the resident lane. So he had to stop at the security gate and talk to the security guard every time he came into the community. Well, guess what? Every time he had a guest, the guest would have to stop and talk to the guard. Same thing. When an Airbnb person shows up and they pull in and they say, oh, I'm renting that house down that street. Well, now we know you're Airbnb-ing, sir, because even though you tried to say it's your, buddies or whoever it is, typically the people who show up, they're honest. They'll say, oh, I don't know where I'm going. I rented it, whatever. So those are important things. And that was all because in that case, that gentleman was delinquent. But you can suspend use rights if an owner is delinquent. You can turn off those key fobs if you have a violation. All of these things help you get an idea of what's going on in the community. Vehicle registration. If you have a whole bunch of, new cars or just different cars that you've never seen before, you might have an idea that, wait, a property is being rented, or, there are tenants here now that are new people here in general. If you require registration, you probably have a good idea of who's there. All things to keep in mind. We have questions about, can we tow vehicles? You can potentially. That's another way to keep all of this sort of, keep an eye on everybody. For enforcement purposes, like we said, ultimately, you can send notices. You should be sending notices to the owner, to the person. Hey, you have an unapproved tenant, or, there's a transfer here that wasn't approved. We need them to fill out an application. You don't necessarily have to say it's an unapproved tenant, so they need to get out right away. Give them a chance to go ahead and fill out an application, run their background check. Might be completely innocent, might be something you can approve, no problem. If it is something where we have a repeated offender, or we have somebody who needs to get out because they are an unapproved tenant and they're a bad unapproved tenant and we don't want them there, and the owner doesn't remove them, we might have to take further steps. You might have to actually file a lawsuit. We might have to go to mediation. Can you evict them? We get that question a lot. You may or may not, the association may or may not be able to step in the shoes of the owner and evict this problem person. It depends on the language in your governing documents. It might be a step where instead we are pursuing a violation against the owner and causing the owner to then remove the person. That depends again on the authority in your governing documents. But either way, there are methods, there are enforcement tools that you have at your disposal to enforce these things. So if you have the authority to review sales, to review transfers, to review leases, and again, your owners aren't complying, you do have enforcement tools. So we wrapped it up. I told you I'd keep us here under the hour, but bottom line, like I said, check your governing documents. That's the biggest thing. Confirm that you have the authority that you think you have. Can you review every single transfer? Or do you only maybe review leases? Or do you only review sales but not quitclaim deeds? And then create the authority that you want to have. You can amend your governing documents if you want to be able to review those things. Establish procedures, proper documentation. Like I said, have an application that makes sense with your restrictions. Don't just off the bat, use whatever your management team suggests. Take a look, make sure it makes sense for you. Act uniformly, consistently. We don't want to run into a question about discrimination, because if we're treating everybody the same, shouldn't be a problem. And just ultimately, again, and then keep in mind, do you have a screening committee? Is it the board that's reviewing it? You may want to look at how you're handling that. And another tip, just random tip that I will give you too, if you do orientations, meetings, interviews, whatever you want to call it, as part of your process, I would suggest that you do that after you have completely reviewed the application, after you've already confirmed that on paper this person's application is great, they have the finances, they don't have a criminal history issue, all of those good things. And you're really just meeting the person at that point to go over sort of the rules and that kind of thing. Treat it like a meet and greet. Don't meet everybody before you have all the information, because again, you wouldn't want some sort of discrimination claim to come about because the person thought that they were approved until the board saw them. That's where you could run into a problem. But ultimately, get all the information, review the application thoroughly before you meet the person. And then treat it more as a meet and greet and go over the rules and that kind of thing. Criminal history, I probably should have mentioned this too, because we were talking about it. Your criminal history policy, that's where you're, very likely to run into a discrimination issue. Talk to your counsel. If your policy is any criminal history means we deny, you are very likely going to run yourself into a little discrimination issue and a problem. Your discrimination, your criminal history policy cannot just be any criminal history means we say no. It needs to be more specific. It needs to be more tailored to really what you're trying to accomplish to keep your unit owner safe, or your homeowner safe. So it needs to be that you're looking at the seriousness of the offense, the recency of the offense, whether it was a misdemeanor, whether it was a felony, if there was a conviction, if there was not a conviction. Again, if someone had a, possession of marijuana charge, which 25 years ago was considered a felony, but it's a felony, but it's from 25 years ago, is that a reason to keep them out of your community? Probably not. So these are all important considerations, but you really, again, screening is fraught with potential issues. This is one of those topics where you really do need to consult with your attorneys and make sure you guys know what you're doing, because you might run yourself into a little issue. All right, Jeff, I can stop talking now.
Have a sip of water. Folks, if you haven't already clicked the chat button, you're not going to see the evaluation link in there. So please click on it now. And then in a couple of minutes, I'll place the link in there once again. After you fill out the evaluation, now she's going to go over a few of the questions that are on there if they're on topic. So she's looking through them now to address, again, if they're on topic and not too association specific. So after you fill out the evaluation, the required part is over. You're welcome to hang out for the Q&A. We want you to hang out for the Q&A, but you don't have to hang out for the Q&A. Once again, after you do the evaluation, submit it. The required part is you fulfilled your requirement. And after Emily does the few questions in the Q&A, I will come back and share my screen for those of you having evaluation or tech issues or questions. I'll go over it more slowly and in detail. I'll show you how it's done.
All right.
Shay, the go to the chat area, not to be confused with the Q&A. The Q&A is where you just type your question. The chat module is different. Click the chat button at the bottom simply so it appears. Don't worry that it says disabled. We can still send it your way, and I'll put the link in there once again in just about a minute. Emily, back to you.
All right. So a couple different things, sort of similar questions here where someone said, I have a unit owner whose fiance wants to move in as an occupant. Does he have to be screened? So completely depends on the governing documents. That's one of those where, again, that's one of those situations. Well, he's not a new owner. He's not a tenant. He's not a guest anymore. Now he's an additional occupant. What do your documents say? Do you want to be able to screen that person? Those are all things you want to look at. It would depend on what's in your governing documents. Somebody asked about the 55 and over survey. And then ultimately, is it a statutory requirement? I'll let you know. I just spoke to someone from the Palm Beach County Fair Housing Agency the other day. We were talking about, or actually it was Broward, sorry. We were talking about one of an issue with a client, and she told me right off the bat, she said, the first thing I look at if we're talking about a 55 and over community is, are they doing their surveys? Are they doing, every 2 years, do they do surveys of who's in all of the units? So you got to do that if you're 55 and over. Now, someone also said, what if an owner doesn't respond to a survey? There is actually sort of two ways that can be handled. You can, and someone else said, what if owners don't respond? What if they don't, comply? What if they don't send you copies of whatever else? Here's the thing. Ultimately, your owners are supposed to do what they're required to do under the governing documents. Those are restrictions, those are covenants that they've agreed to comply with. Now, we all know not everybody does everything they're supposed to do. So you can ask, you can send a demand letter. Your management team should then send another demand letter. Hey, you didn't respond to this. We need this from you, ASAP. You can have your attorney send a letter. Now, if we're talking about the 55 and over survey, there's a slight variation there. You can actually have a board member sign an affidavit saying they already know who's in there and certain things. There are other steps, but we won't get into that in too much detail. But ultimately, these are things you should be able to enforce. You can have your attorney send a demand letter. You can, again, you can push it where we end up in mediation, potentially when you're telling someone that, their tenant is going to have to leave because, or you're going to, turn their transponders off, or you're going to do other things. If that owner's vehicle is there and it's not approved, or that tenant's vehicle is parked there and it's not approved, it's going to get towed. There are all these methods to sort of force compliance. So talk to your attorney and see what you can do. Let's see. Transfer fee, application fees. Someone again asked for that. Interesting, because that is the issue. Ultimately, the statute, and when I say that, it's only 718. Only 718 talks about transfer fees, not 720, not 719. Only 718. So essentially, the way the division looks at it is any fee collected in connection with an application with a transfer is considered a transfer fee. So application fee, transfer fee, I would tell you they're going to look at it the same way. You can't sort of cheat the system and say, well, this is the application fee and this is the transfer fee. So we're collecting 150 and 150, or 150 and another $100. I mean, you could try it, but I'm telling you, if someone complains, the division's probably going to tell you violated the statute. So be careful. All right. Some of these other ones we did get into. Right. If someone shows up and they're an Airbnb, can we deny access to the unit? That can get dicey because, again, you don't typically want to deny access because someone could, in theory, have a guest. So you have to kind of let them get to the property. But ultimately, you want to treat the real problem here. You want to go after the owner because now you know that they're in violation, that they're renting when they shouldn't, or when they're not getting approval, and you send them a letter. You can take some other steps. All right.
That could be one of those updating your the importance of updating
Yeah.
documents issues, which we
Yep.
can help you with as well. So,
Yep. All right. So we're over time. Is there anything else we got to tell them, Jeff?
Now you just the best way to reach you, and then I'll go over the evaluation, and you can head out.
All right, cool. So best way to reach me, I guess you can always go to our website, and then you can always shoot me an email. I'm just egannon@kbrlegal.com, EGANNON at kbrlegal.com, or just check our website, kbrlegal.com.